I'd like to call this work session of the Assembly to order. We're here to discuss the Chugach State Park Access Plan. And we'll start with introductions. Mr. Steele.
Tim Steele, Assembly. Bill Starr. Ernie Hall.
Bill Evans. Dick Trainee.
Toby Johnson.
Patrick Floyd.
Paul Holman-Zimmer.
Dean Tobish, Municipal Planning Department.
Monica Alvarez, Department of Natural Resource Planner.
We have two others too.
Oh, Tom Harrison, Superintendent, Chugach State Park.
Claire LeClaire, Deputy Director and Chief of Field Operations for Division of Parks.
Welcome to each of you. Thank you for joining us. And just for the record, Mr. Bosky and Mr. Peterson are in the vicinity, but not in the room at this moment. We'll try to note their presence when they show up. Mr. Tobish, are you going to take us on a walk here?
Yes, sir.
Please do.
Thank you. I have a PowerPoint that we hope to give you some basic information about the park, about the process, and about the plan. And please interrupt me if you have a question. We'll try to answer it as we go. We've got state staff here to answer hopefully anything we can come up with. So, first, some information, facts and figures on the park. I'm not going to read through these, but these give you an indication of the importance of the park, the strategic location of the park within the state and within our community. A couple of important things to point out is the size of the park there at the top, the numbers of trailheads. We have 32 main trailheads in the park, distributed sort of unevenly across, and I have a slide to show that. And the parking spots right now count out to just over 1,700 for those 32 sites. So why do we have a plan? So this is sort of a visual for you to give you some examples of why we've embarked on this plan. And really, public access to Chugach State Park started to become an issue, a conflict with the community back in the 1980s when the community started to really boom. And it continued through the 90s, and it was highlighted in the Anchorage 2020 comp plan in 2001. But this gives you some examples. Basically 4 of the 5 photos show you the overuse aspects of the park and some of the trespassing concerns throughout the interface with the park. There on the left, up on the hillside, there's actually a gate across one of the public roads to try to restrict public access. And this is an older photo of Glen Alps, but it's indicative of the concerns that problems that still show up there. And then finally, we want to increase convenient, secured access for the future generations. So I have a map here if you want to look at it closely, but this is a large map of the park. If you can see them, the dark spots are the trailheads, the major trailheads maintained by Chugach State Park. And of course, they're distributed mainly on the southern and eastern flank of the park. There's nothing else north or east. But they're felt to be uneven. You can see that they're concentrated down here in Turnagain Arm. And those are the bulk of the numbers of parking spaces are down in that area. And then as you move north towards Chugach, Eagle River, and up to Cluna, there's much less access and parking.
Let the reveal Ms. Johnson's presence. Please continue.
Okay. Just some notes there on the right talking about speaking to the need for the parks plan as far as getting people into the park. So we threw these maps together. They're hard to see, but they're illustrative of comparison between Chugach State Park access now in current terms, which is the lower slide here. This is Eagle River Greenbelt, sort of the western end of the Greenbelt. This is Chester Creek Greenbelt. So Chester Creek Greenbelt looked much like Eagle River Greenbelt in the 70s and 80s. We managed to get federal funding to preserve the Greenbelt in Chester Creek, and through that, we had a platting process that allowed for all of these public access points in Chester Creek. You know, the density population obviously is higher than here, but someday, at least the western end of Eagle River Greenbelt is going to have higher density, more population. So it's the same idea. We want to use platting, future platting actions, possibly some acquisitions, to maintain and get more secured public access in the park the way we did with Chester Creek. So this section of Chester Creek, roughly from the university down to Westchester, about 4 miles, 9 parking lots, 35 pedestrian access points. Eagle River, similar distance, maybe even farther. We've got 4 parking access, mostly concentrated down here by the campground. And 7 access points scattered for that whole mile. So just a way to comparison for you to put it in perspective.
Thank you. Mr. Peterson, please.
I'm behind you.
So I won't read these, but these are out of the plan. Sorry, I need to go back one to show you. This slide here, that top wording is the purpose of the plan that State Parks has kept with since the 80s. So these are the objectives in the plan, and I won't read these. These are early on in the plan, but they cover all the reasons, all the purpose statements for why we want to do this plan, why the state park and the municipality jointly need this plan. So we thought this might help you to talk about what the plan actually is. On the left there, it's a long-range planning document. It's essentially a recipe book for where future access points might go and how to get them and what they will be. They're not all going to be the same. Some are simply foot easements, pedestrian easements. Some are parking lots. Some range in between. And it's a legal framework for dedication to the private process. What the plan is not, and this got confused a little bit during the Planning and Zoning Commission process, it's not a trails plan. It doesn't say we're building a trail here. It's not a park development plan. It doesn't say that certain facilities are going to be built within the park. It's not a project list. It's simply a potential access site for future access decisions. It's not a parking lot plan or a parking plan, and it's not a facility plan, as I said. The state parks maintains a different plan, what's it called, the land use management plan, that addresses most of those details and items on the right-hand side there.
Ms. Thompson has a question.
Actually, I'll wait till they're done. I just want to be on the list.
Okay, thank you. Mr. Training on this one?
No, just to Dan.
Scott.
Okay.
Proceed, sir.
So this highlights some of the major points of the process, the planning process. It actually started with scoping by the state back in 2008. Some highlights of the state process comments. They held numerous meetings out in the communities over a 2-year process that culminated with their version of the plan in 2010. Public process for the municipality began in 2011, 2012 through the Planning and Zoning Commission. We held 2 public hearings in September of 2012 and then in the spring of 2013. We did I have to remind you that this is a land use plan, it's a comp plan, and our notification for those is different from a zoning action. With a zoning action, we would notify landowners within a certain distance. With large plans, we don't do that. We just do a general notification to the community councils and agencies. Planning and Zoning Commission asked us instead to treat this like a zoning action, so we actually started over and did notification to landowners. I think it was within 1,000 feet of the state park boundary. So we generated a mailing list and actually notified all those people, as well as the standard process. And again, we did an issue response to all the comments we received twice. We did that. So that sort of summarizes the process. So this is a slide. It's very busy and actually hard to read, but we wanted to throw this in to show you how the planning process works that culminated with the dots on the maps. State parks and the Muni combined our planning maps, mostly trails plan maps. So the items in yellow and black and green are items identified on municipal planning documents, either our area-wide trails plan, some comp plans, district plans, bike plan, things like that. So those lined up with locations where subdivisions were expanding, where population growth was anticipated, to culminate with these target dots. So these aren't just random dots on maps that looked good. These were based on municipal planning connectivity documents. Access to trails.
Sorry to interrupt.
Sorry.
The plan that's in front of us for consideration is labeled 6.3, but it's not this map.
Correct. This is a planning map that we use to get to that.
Why don't we have this map?
We could, it wasn't included in the original because it's much more detailed, more complicated.
Well, you just titled them the same, that's all.
Well, it was the example we used. Yeah, we took that as an example map to show Planning and Zoning Commission. We could certainly add it, but
So the overlay with the trails plan is particularly important.
yeah.
If you're really looking long-term, some of those trails plan access points are funded already, so we've got that momentum already moving down the road. So it would be helpful to
It's a
see
good planning map, absolutely.
that in particular to the various units. Well, I would like it.
Okay. The other thing to mention about the park plans access dots are that they do represent studied areas. State parks delved into the information about each area, from soils to wetlands to hydrology to topography to seismic area. So those data were placed in their compilation for the planning effort to essentially vet the sites. And a lot of sites that could be potential future access were removed because they weren't sustainable, they weren't possible for those reasons. Here's another example map, like previous, for the hillside area, the south end of the hillside area, showing the same thing. Municipal planning trails, access points, access connectivity are overlaid on the state parks access map, just to show the lineup and the targets for each of these. So briefly, how the plan will be used. The top is how the state plans to use it. The bottom is how the municipality plans to use it. Basically, legal department recommended that we adopt this plan as a comp plan element so that it serves as a formal basis for requiring dedications and future planning actions, which is essentially the main way these will be added over the long term. It's an opportunistic approach based on planning. It also basically codifies what the community has said through other comprehensive plans about the importance of State Park and the need for access to Chugach State Park for the public. So this, we'll go through a little bit, we can go through this and how to read the maps, but this is from the part of the legend from the maps, showing the important points that ended up on the maps, the graphics. There's the terminology, the differentiation between a secured access point, which is essentially existing formal agreement of some sort, versus unsecured, which is not legally reserved at this point, it's a potential. We have access categories about improved, unimproved, or potential. And then we have on the map, you probably notice very large areas of pink, which are giant parcels of opportunity where future plating action may provide access opportunity, versus an area of high suitability, which is a site that's been identified by topography, et cetera, to be highly suitable. And then we wanted to make sure you've already heard some of the public's concerns, I'm sure, either via telephone or some of the testimony from last week's public hearing. And this is, I think, a pretty complete summary of what we heard through the planning process, basically since 2009. Nothing surprising, really. So we wanted to jump into some examples for you, and we chose a couple that you've already heard about through the public testimony. But this is map 6.3, that same map we showed earlier. And it shows 4 access points that we specifically heard concerns about from the public during the Planning and Zoning Commission process. And jump in here, state parks, but basically this is one that the community, the neighborhood and the subdivision directly below that was quite concerned about. Their main concern was what future users, how future users may impact their neighborhood, either via trash or parking, etc. This is Eagle River 10. This is up at the top of a road, platted road. This is Dr. Peters' parcel that you heard, he testified. This is below him, but in the same general area. And then this one down here is a greenbelt access point through one of the existing subdivisions. So this site here, Eagle River 5 and Eagle River 18 and Eagle River 10, I think, if I recall, the recommendation is to maintain a section line easement so that the local community essentially has a secured future access into the park. So those three, this is more to maintain access so that the road will continue through this. Essentially, this is not parkland, this is state land, HLB land, and mental health trust land. So essentially, this is considered, at least in part, developable, future developable land in subdivisions.
Ms. Boski, you want to ask your question now, or you want to wait till the end?
I can wait to the end.
Thank you.
And then we'll just delve into it a little further. The wording on the map is just showing the language out of the plan in the table assigned to each site of what the plan recommends. So Eagle River 10 is Dr. Peters' parcel at the top of his road, and all the plan basically says is this, is to retain the section line easement, and I have another map to show you that, so that there could be at least potential pedestrian access through the area to get to the park. And then Eagle River 12 has some more detailed information about maintaining access corridor as the land develops moving to the park from this existing right-of-way here. And this is just a plat of Dr. Peters' parcel. His house and land is down here. He does own this piece. And here's the section line we're talking about here. And you can see it goes into the park. This is also a section line. So let's jump into Stuckagon area where we also heard public concern. I'd like to give you a little more detail on this. The public is concerned about this area here, this H3. Right now, this pink area, rectangular site, has now been merged as part of the state park. It's no longer private land. So the state park's interest is to create a trailhead and a parking access point. And here's the language that the plan recommends to do that. To basically, as time allows, in the future, they will develop a parking lot, and it's considered a small lot, which I think is restricted to 10 to 20 cars, with details to be worked out with the community council in the neighborhood. It's a logical location. It's in the park, away from the houses, away from the public roads. The neighborhood had a concern about this H1A. They were concerned that we didn't label it as secured, even though it essentially exists. We did not label it as secure. We kept it as red because of a request from J-Bear. It's on J-Bear land. The access point into the park, that red line, is a trail. It's in J-Bear. They do not want us to show it as a permanent public access in case their needs change. H2A is a site that the community thinks should be a parking area. There's not enough room, as I understand it, and it's not nearly as suitable as farther into that new park area. And then H6 is an existing parking lot that the plan here, the language recommends possibly enlarging to take much of the traffic out of the neighborhood and keep it here at the entrance to the neighborhood. So it seemed a logical space to upgrade. So real briefly, why we want to adopt this as a comprehensive plan element, besides the fact that legal had recommended it such from a legal standpoint. This plan has been mentioned in community comp plan documents since, as you can see, since the 1990s. All of those plans identify the park as a significant and important public resource to the community that needs additional access. The Hillside District Plan has a lot more specificity and policies that speak to it. As we said earlier, the plan codifies the importance of this public resource and provides a legal foundation for securing dedications. And it also now comes into play with Title 21, which has been adopted, which has language making this connection to Chugach State Park Access Plan here. This is the new language that's in the adopted code, and you can see it's referenced here, right here. And this is in the section for dedications. So just a summary, the Planning and Zoning Commission had 2 public hearings. They passed the plan in the spring 2000 with resolution there, and their resolution includes 27 conditions and amendments and an addition of 2 maps. And we just kind of, that bullet there summarizes their clarifications and the text changes from the document. And then, please, questions?
I know there's a bunch. Thank you, Mr. Tobish. Ms. Johnston, you were first.
First of all, this history, this was a state plan to begin with.
Yes.
Just as a planning document for the park, correct?
Yes.
And I think the first inventory was done during the Knowles administration by Pat Rochelle. Am I correct?
The original inventory was 2000?
2002.
So this has been a state process that's gone on since 2002, am I correct?
Well, there was the access inventory that was done in 2002, and then we embarked in 2008-9 on this access plan that was jointly developed throughout the process with the municipality. We just started the state process first.
And by having it as part of the comp plan, then we will use it in our plating and in Title 21, am I correct? So,
Yes.
So our engagement as a municipality is in Title 21,
Yes.
and as we adhere to the comp plan if we adopt this, am I correct? Could you go back to the Title 21 there? Since I was one of the writers, what we did with Title 21 is that we gave an option for right-of-way or easement. Is that your understanding?
Yes.
Okay, so just for everybody else's clarification, if the park or the community or municipality wanted to take one of these undefined areas and make it into a park access, the Title 21 would kick in on how that is planned. And say the doctor in Eagle River wanted to develop his land, and he didn't want to use, if he wanted to have a pedestrian access, he could have it as an easement, so it would not detract from the size of acreage for his lots, just for your understanding. And I know I'm on a work session, so I should be asking questions, but I just wanted to make that clear. One other point I would like to make clear is state statute, you cannot condemn land for recreational purposes, am I correct?
That's correct.
Okay. Let's see if there's, I will say that Mr. Evans and I have an S version that will be on your agenda, and it will be addressing, one is the 5-year amendment that was by planning and zoning, and our S version has it as a 5-year point of reporting versus withdrawal. And the other amendment, Amendment 8,
Planning.
the plating board, that it will be a combined effort of the superintendent of parks, plating board, and the community. So that's it. Thank you.
Thank you, Ms. Johnson. Mr. Starr, do you have a question on Ms.
Well,
Johnson's point?
in using Mr. Peters' example, if he has a 40-acre continuous tract, essentially upon subdivision, his request to subdivide, he would be required to take a certain portion of that land and kind of turn it over to public use? Is that how that?
No,
No.
no. The state would look at it and go to him and try to negotiate something. Right now, what they're looking at doing is just using the section line.
Well, we wouldn't let him subdivide, though, based on the Title 21 right, and we wouldn't let him subdivide the land.
Without some, so, yes, if you were going to subdivide, Connie Ushimaro is doing this up in Potters
Yes.
currently, and she has a subdivision that borders the park. And in that subdivision, there will be a trail access for her subdivision to get into the park.
But it's private land that's essentially being turned into public use easement.
It could be. Yes, and that is in the Title
Mr.
21.
Tobish, would you like to address that
Yeah,
point?
if I could just jump in. In Dr. Peters' example, if he came in for a future plat and was subject for platting, through state parks, we would look at this plan, and the only thing it says about his parcel is not to vacate the right-of-way, which is,
Well,
Right.
in your plan, I was
Sorry,
looking at
vacated the easement.
the enforcement language inside our new Title
Oh, in the
21. Yeah, with the development, director of development having the final say, and then some of that. That's a little challenging for me as to how you get uniformity there. Certainly if somebody wants to sell it outright or negotiated settlement, that's a good way to go, but when enforced actions through the planning action board or the department director authority given in Title 21, that's more concerning. I have to study that a little bit more.
one way to help think of it is that the state park, if you think of the state park as essentially private land that requires access, then it's not any different essentially than private land uphill of a different subdivision.
Well, the only challenge I have with that statement is inside Title 21, it specifies that the private property owner is required to subdivide under those terms, and he can't unless he does. He can't subdivide unless he does that. That's a little bit challenging, because then what's to say his subdivision agreement is accepted by the public? If Mr. Peters says, hey, I'm fine with a walking trail, which I don't know if he is or not, and that goes out for public discussion, and they say, hey, no, we want something else, then you've held this gentleman hostage while somebody else determines what's appropriate access for his subdivision. And I don't want to debate you, it just seems to be you're stuck more in the verbiage of Title 21 than the adopted plan. And that's where you hold them hostage.
The way the planning board would use this plan would be to reference the table for each site. And each site has specificity about what's considered to be appropriate at that location, whether an easement or whatever.
I don't disagree with that, but in conjunction with that would be a development plan, actual parking places, actual lights, actually garbage disposal, that's more likely to go in front of a planning action with a full developed plan for approval. And again, if Mr. Peters, using that example, doesn't agree with that or can't afford that or whatever his statement is, then you basically, he's going to get a denied subdivision.
I want to move on.
But I'm happy with that. I think that according to Title 21 is the document that's missing in all of this.
Exactly. And I can further clarify that off record.
Much appreciated. Mr. Trainee.
No, I wanted to hear from Mr. Starks. I was concerned about how this impacts the Chugach area.
We have a lot of undivided land.
I used to have land out there, I had 5 acres in E20, and if somebody told me they wanted access to Chugach State Park to my property, I have a problem with that. Years ago, we used to have a little border wars there. We'd go down a road that wasn't developed, you'd find a chain across the road, and you didn't go beyond the chain. That's how Chugach used to be. I don't know if you're any different now.
Ms. Domboski, I had you next.
Thank you. Can you go back to your slide on public comments, please?
Hopefully. Oh, to summarize the process?
Yes.
There?
No, not summarize the comments that you received.
I don't have that. I didn't have a slide.
Yes, you did.
You
Keep going.
the
Towards the
complaints, public concerns.
Oh, okay. I don't remember where it was.
I don't have
Very
a
early.
packet, so.
It's early. No, not that early.
Okay, so this is what's interesting to me when I watched your presentation. Because what I'm hearing from people of the public, of which, when I was in Thunderbird Falls, there's a member who owns a piece of property right next to it, and he was not notified of it. So I don't know about the 1,000-foot that was sent out, but he didn't know anything about it. His name's Al. I don't know his first name, but it was right off Raven Court. But in here, what about those people that currently don't have an access across their property, that don't want to give you one? I can't believe, out of all the comments that I've heard about the public wanting to preserve their private property rights, it's not listed on that slide. You never heard that?
For private property rights?
Yeah.
Sure, we did.
So why isn't, to me, that's one of the
just-
most fundamental issues.
Well,
And it's disconcerting to me that it's not even talked about.
yeah, I'm sorry, it's an oversight. Certainly, we definitely heard it. Not in a lot of cases, most of the concerns clearly were on these categories. We did hear a few where it was concerns about property rights.
Okay, so let me, on that line, if I can follow up. So as I read this plan, essentially, this is going to become a tool for specific plating actions or maybe things that come before that people need permits, whatever, for. So, you know, in conjunction with Title 21 and the Chugach State Park Management Plan, which I've yet to see a copy of, this is a very powerful tool because you could have a private property owner who doesn't want to give somebody an easement to their property, but essentially I will use a stronger term than Mr. Starr used. Instead of being held hostage, the government's extorting from them an easement maybe they don't want to give. So how do I respond to a constituent who says to me, I don't want to give the easement, but I still want to develop my land?
Well, if you had an example, examples help. A lot of the concerns we heard from property rights or the takings was relative to those large pink parcels that are unsubdivided.
Right.
And the plan shows a dot near them, for instance. And really, all that's showing is, the main issue is, if somebody wants to identify a new subdivision, let's say up by Ramsau, which is the site where we heard that, in Eagle River. I think the plan basically says, use the document to identify a future road access to make sure that public access continues through the new subdivision to the park. That's really all it says. And so how does that play out? If that landowner comes in to subdivide a 40-acre parcel, we would make sure that their road system through the subdivision continues to the state park boundary.
And just to follow that, if it's a 40-acre parcel and he wants to build his son's house next door, that's not a subdivision. It's still private property. How do you justify telling somebody they have
Well, we wouldn't do it in that case.
It says who? Is that up to? I mean, you say that now, but I don't know who the next director is going to be.
You can't do it. You can't do it, essentially. There's no road going to the house, right? So in that example, they're probably having a driveway from the existing adjacent road to the new house. You wouldn't have a road decision to come
But
into
if they
play.
put in 3 or 4 houses, then it may.
You wouldn't be
what's
able
the threshold?
to, you wouldn't, there's no nexus between the 3 houses and the whole subdivision to the parcel, to the state park. It's only where the plat allows the action.
Mr. Johnson, you want to help us out as our telephone?
Can I add and I don't know if this will help or not.
Probably not.
Well, the verbiage.
Excuse me. If you have a subdivision that is here, and you have another subdivision behind it, and we have this on the hillside, you have it in Eagle River, where there's large acreages of land, and you are subdividing the first one that is on the road access, then that private developer has to have an access to the land behind them, no matter what. And that's part of the full subdivision of that piece of property. So if you have 40 acres with another 40 acres behind it, you have to put a stub that goes out to that other 40 acres if you're going to have subdivision with public roads. Now, a public road and a private driveway are 2 different things. And then the other aspect is why I keep asking for clarification. You cannot condemn property for recreational purposes. So you can't say, I'm taking that property if I'm going to have my family all around me in my 40 acres.
But just if I can ask you a question, on that line, you may not be able to take it, but if somebody, now we're talking about not a subdivision behind us, we're talking about the state park. So what you're saying is, we may not be able to take that, but we can force the easement, essentially, or we could just deny the replat.
You can block it. You can't block access. But you can,
Okay, this is going to turn into debate very quickly, and I'm not going to agree
I
with.
understand we have a difference in interpretation of the.
Oh, it'll be
Let us
clear on
proceed,
Tuesday.
please. Mr. Harlan, you are next in queue.
Okay, so getting into the Anchorage area, Basher Community Council had wanted, in fact, I probably moved to put their resolution into the record. I know that they had a resolution from the council. I'm not sure if that got into the public comment period or not. But they've been very amenable to more access and more parking. And in fact, they've made recommendations, and I believe you specifically talked about H2 versus H3. They're very concerned about H3, and yet they think H2 might be a better, and I heard you say, well, one's more suitable than another. I don't know if that's subjective. I don't know if that's based on the way the slope of the ground. I don't know how you can justify it if the community's saying, look, and it may even now be moved. When did that parcel become state park land? I mean, how recent?
It was last fall.
Last fall.
Okay, I'm not sure the community may be aware of it. I'm not sure that.
Oh, yeah,
They are aware.
Okay, well, they're excuse me, as recent as this morning, I got a call from a couple of folks that are spearheading that effort and trying to say, we're not against access or more access, but they are against some of the proposals, and again, this one where you say more suitable. I get that you're saying, just because it's on there doesn't mean it'll ever even develop. And I'm gonna use a different example, but there are literally, according to some developers, hundreds of paper plats on city streets and along subdivisions in Anchorage that likely will never get developed. And yet, when someone who owns a piece of parcel or property that's one of those paper plats, and they're trying to do some improvements, they've got to abide by Title 21 codes because it's a paper plat. So my concern is that we're going to go out here and throw a bunch of red dots and paper plat it, and then it may never come to fruition, and yet we've inconvenienced or scared a hell of a lot of people. So I'm wondering if maybe we scale back a bit with the red dots and maybe put a few, we'd like to kind of commentary, and I don't know, make it a green dot or a yellow dot. I don't know. I don't know the answer, but I hear the community concerns that, we have all these paper plats that potentially are going to be on this map that are going to create, in my opinion, an unnecessary row that we're seeing now, because I think one of the things I saw later in the slides was there is no state funding for much of these projects yet. And I think that's going to be contingent on a lot of your community members that are in those areas lobbying against your efforts if they're not happy. So we can throw what we want to up there if we're not going to be getting the buy-in from the community that lives in that area. That makes sense?
Can I ask a question on that site? Is that the site where there used to be the restaurant historically?
It's across from
But the same,
that same area.
the same area where the restaurant was
Yeah.
stuck again?
So they're saying that they recommend H2 being a larger space, a larger lot, and forgetting the H3, because you could accommodate that under H2 and forget the H3, but make it a larger spot in H2. I believe that's what I heard the community saying. Is that what you're?
Monica can answer. As I understand it, H2A is now no longer available. Is that right?
Yeah, it was a paper plat, it was a temporary turnaround easement, and there's a home there now. So H2A, the turnaround easement was meant for construction, we had listed it, it was on the paper plat, but effectively it wouldn't be suitable for parking because we wouldn't probably want to situate parking right next to somebody's home. So the temporary turnaround easement's pretty much gone. It was there for construction purposes. Since the property was purchased and this plan went through this planning period, a lot's changed in that neighborhood. I was pretty surprised last time I drove up there, and most of the lots now are developed, which is really different than when we first started the planning effort.
And a follow-up. And that, speaking of that, and going to Dr. Peters' land, you just made an important distinction and comment. What about people parking? If you say this is a public access point on a lot line, section line, or whatever you want to call it, guess what? Where are people going to assume? I mean, yeah, maybe you say, well, it's intended for pedestrian access only from those who live in that subdivision. What about those that say, hey, this is a good point, it's a public access spot, and you start parking along the road that Dr. Peters had said is very, very narrow. You barely get one vehicle in there, and they start parking along the road that's near the section line. I mean, how do you address
And
that?
that's definitely a long-term existing concern with the community in general. The idea for the plan is that over a long term, there will be more access locations to disperse the public, number one. But number two, and in your packet, there's a map that we added right at the end that shows the priorities for development sites within the park itself. So future trailheads and so on. And the plan's fairly clear that, and the commission made it clear that future parking spots and trailheads, larger scale trailheads, are intended to be inside the park boundary, away from the streets. We're trying to get the people out of the streets and off the trespass issue. But it's definitely an existing concern at every smaller trailhead. Where do you park? You know, Grandview up on the hillside is a classic example.
And to add to that, I have to say that the park went through, I think you remembered maybe years ago, up on Glen Alps, and the issue of vandalism and, you know, how to, so you have a huge parking lot that has no houses around it. And I think the state park then started to say, you know, do we have parking lots that don't, the better parking lots probably are within a community, because houses can then see what's going on and you don't have the vandalism. So there's a really a push and shove there. I mean, I think it should be on parkland, and that is now on parkland, but you do have an issue of, I think probably we're going to have security cameras and other things, because the houses don't want to have anybody parking near them. So it's a push and shove.
Mr. Starr?
The 1,706, I questioned that number, partly, you know, for the undeveloped sites, you know, like 7.2 mile access point, I think it's 7.2, or what do you call it, the valley there. You could probably hold 400 cars.
On Eagle River.
Yeah, at that one. So the 1,706 that you show as your baseline, I'm thinking that number's pretty low. I mean, you've got Bird Creek, Bird Point, and those are massive sites for parking, in terms of parking, overall park access for the park. I don't think that number's correct.
Well, we can try to dial that in, but that was what state parks, when they did an inventory.
Well, maybe paved and lined, I would grant you that, but, you know, upper Arctic Valley, that lot's, you know, 300 or 400 cars.
It's not a public access point.
Pardon?
It's not a public access point, it's privately owned.
Yeah.
Even across the gate on Fort Richardson side, yeah. Anyhow, that number seems to be a little bit, if the driving force is the parking lot number, I'm not certain that that's really
We could try to
the
do it.
right. Paved and lined, you might be right, but in terms of just general practice use, you know, 7.2 can handle 500 cars at it. I'll bet you.
Do you guys know?
Are you talking mile 7.4 Eagle River Road?
Yeah, Eagle River Road.
Yeah, no way. I mean, if you look at Glen Alps, you know, that's 150.
Well, it's 7.4.
You know, then you add the other piece to it, and that's not as large as Glen Alps. When you know, there's a turnaround and whatnot, but I couldn't tell you how many cars, but it's probably in the, you know, 50, 60 range.
7.4?
Yeah.
I've seen that with trailers and snowmobiles.
We'll try to get a.
Yeah, it's fair. I just, you know, what we're trying to do here is it convenient walking access to the neighborhood feel where you can go down the side thing and maybe a car or two, or is the goal to provide larger parking? And sort of the initial started out as we've only got 1,706 places to park. Well, what's the goal?
The goal is both.
For
The
paid
goal
parking.
the goal is to expand the access for convenience and to disperse the public. You know, this is an example here. This is Stuckagin Basher area. For Northeast Anchorage, this is the first location where the public has any access to State Park. If they don't go here, they have to go all the way down Elmore, around Bicentennial Park into the northern part of the hillside. So this, you know, these are essential strategic locations for public access, because otherwise you've got Jay Bear land where public access is not allowed, essentially.
Mr. Horgan had another question or comment, I think.
Just more of a comment that, you know, I'd like to say that, again, from the constituents that I'm hearing from, they're not saying they're opposed to more access points or having a plan. What their concerns are largely is something that Ms. Johnson just mentioned, and that is, as you build these turnouts, pullouts, parking areas, or access points, one of the major concerns they're seeing, of course, you've got it listed up there on the trash and the noise and litter, but is security of vehicles, which also spills into nearby residents and their lawns and their land and their storage lots and whatever their properties are as it goes in. So they're looking at,
from a different perspective perhaps than just, hey, this is a good idea to throw a pinpoint on a map. And I know that's more than, you guys did more than that. I'm not want to negate your efforts or your, trying to set out long-term goals of trying to identify these parcels. So I can't say enough. I believe, in this case, less is better, less is more. I don't know how you want to call it. I just think there's just a whole lot going at people that's creating a stir that I'm not even sure is really necessary, honestly. I don't know that I go back to this thing about paper plats that are 50, 60 years in the making, and nothing is ever going to come of those parcels. I mean, there's been a suggestion to take all those paper plats and eliminate them, just because it creates more of a stir and a hassle than it does the need to it. So I think I also saw, and I'm sorry to go on here, but that you were saying that review of the plan would be ongoing. Would there be a process to remove a red dot from a neighborhood based on comments, concerns, and the probability of it ever being developed?
I think that right now the plan doesn't have any specificity about removing. The renewal process would be the only one.
There's a review process, and there's a review process that Ms. Johnson
Again,
has to
I'd like to address that, again, H3 from planning standpoint and location standpoint is the best site to put a new parking lot. And it gets people off the street. Right now, people access, there's serious problems now in Stuck Again, and this is a way to get people off the public streets, both focusing them here and back up here into the park. So.
Ms. Johnson, we're about ready to wrap up here?
Yeah, this was just one wrap up. Another concern, and I actually spent some time in Juneau trying to address this, is impact on your subversives, your limited road services. And we're all very familiar with the unfunded mandates that the state has, and this is one of them. I will say that in Mr. Evans, in my district, when I do hear the complaints, I do have to also turn that around to what Mr. Flynn loves to remind me of. We don't pay for the roads in Anchorage that we use on a daily basis either, but I'm just saying that I have felt that if there was ever a chance in the state budget where the number of cars, the size of the parking lot would be assessed for property tax for that service area, that would be a great addition.
Good luck with that one. Ms. Gray Jackson.
Thank you, Mr. Chairman. Just to finalize all this in relationship to our process on Tuesday, so that we're organized. Have you seen the amendments that we've gotten from our constituents? Mr. Train and I received all of them, but we only received one from Rogers Park Community Council. But have you seen any of them?
I've only seen one formal comment from Rabbit Creek Community Council.
Okay, because my point is, Mr. Chairman, that I think, I mean, I don't know how many amendments folks are going to bring forward, but that we should follow the same process that we did for the wetlands, so that we can, be organized on the floor on Tuesday. Thank you, Mr. Chairman.
Ms. Gray Jackson, you said your S version is going to be out in the addendum? Your S version?
We asked this.
I saw the addendum and I just apologize, I didn't specifically notice if it's on the addendum or not, but I think Ms. Johnson and Mr. Evans submitted it in time for it to be on the addendum.
Yeah.
If it's not, we could distribute this afternoon.
Absolutely.
And for others who have amendments, if you would kindly get those to the clerk's office for distribution this afternoon.
The sheet that you mentioned about the priority and the development plan, you waved a two-piece sheet. Where is that? You just made mention.
Oh, the new map?
You made mention that there's a certain priority that you guys have
Yeah, sorry.
established.
It's this map here in the back of the P&Z resolution.
That's in your packet?
It's in your packet.
Well, which exhibit is that?
I'll have to look for you. I'm not sure. I don't have the full packet in front of me, but it was part of the plan.
Because the action that's in front of us is to adopt Exhibit A, and then the recommendation inside the ordinance says to take Exhibit B, I think is what it said, and adopt it in conjunction with our approval. So
Exhibit B is the P&Z resolution packet.
I'm quoting here, but I just wanted to make sure that that's not new data that's been submitted after the original submittal.
No, it's not.
I'll look it up, but that's got to be then an Exhibit B if that's what we're adopting. And then there's an Exhibit C under recommendations. Mr. Weaver, is that the one you worked on?
Yes, that was one.
Yes.
Yes.
Mr. Trainee?
Has the planning department seen this version yet that's being brought in by?
No, I did talk to Dennis this morning. I don't think Dennis had finalized it as of about 11 a.m.
Well, apparently not on the addendum, so that's probably correct, but we'll try and get that out to everyone today.
Thank you, sir.
Yeah, I understand. Is there anything else before we wrap up?
The good news is that our municipal attorney did get a moose.
So did Mr.
So did I.
Was he in the park? Sorry. All right.
You said your son did.
With that, we're adjourned.